Today is the 224th Friday group meeting. The topic is new criminal laws, BNS and BSA conclusion. Our beloved senior advocate last part 1, 2, 3, 4 and today also take 10-15 minutes in final conclusion. After that bouquet of flowers, vote of thanks and little bit sweets distribution. So we have to give some big claps. It's going to be. Mr. Justice Nagamuthu is going to deliver a final lecture conclusion. Sir, now you initiate your final this thing, sir.
Good afternoon, my dear friends. Justice Adhiniyam. All our friends, more particularly senior lawyers, Mr. Maran, Mr. Mr. Balaji, and my dear friend Mr. Suraksha, who is responsible for these happenings on these 4-5 days. I am very grateful to all of you. I say good afternoon to all of you. Today is the last day of our continuous lecture. You all know that we have already covered two major criminal laws which have been introduced. One is BNSS, repealing CRPC. The other one, BSA, repealing the Evidence Act, which we covered yesterday. What is left is the IPC, which has been repealed by BNS. There is today I have been given 15 to 20 minutes time within which I got cover this act. Now, before going into the details of this act, let us have a quick look into Article 20, Subclause 1. It directs, no person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. When we are going to implement this new penal code, that is BNS, we have to keep in mind this constitutional mandate which says that if a particular act is declared punishable as an offence on the date of the commission of the said act, then only he can be prosecuted under the said act. Now, so far as the offences which were committed prior to 1/7/2024 are concerned, they are to be governed only by the Indian Penal Code. This new act would not be applicable. The new act would be applicable only in respect of an offence which is committed subsequent to the crucial date, that is on or after 1/7/2024. Similarly, there are some offences for which there is enhanced punishment prescribed under this act. In the corresponding earlier provision in the IPC, the punishment would be somewhat lesser. Question may arise whether the punishment which is the greater in terms of number of years can be imposed in respect of offence which are committed prior to the coming into force of this act. No, because of the constitutional mandate in Article 21. So let us be very clear on this, that this act would be applicable only in respect of offences which were committed on or after 1/7/2024. Let us not have any confusion, because while referring to the repealing and saving provisions in the BNSS and BSA, we had different opinion, different idea about that in that context. Don't bring those interpretations or understanding to this act when we are dealing with this repealing provision under section 358. But 2-3 things you have to see. in this act also. Section 358 speaks of repeal and savings. Let me read it, then we will have a little bit of a discussion on that. The Indian Penal Code is hereby repealed. Therefore, in respect of an offence committed, any act done after 1/7/2024, there cannot be a prosecution under the old IPC because IPC has been repealed. 2. Notwithstanding, this is a saving clause, notwithstanding the repeal of the code referred to in subsection 1, it shall not affect, number 1, the previous operation of the code so repealed or anything duly done or suffered thereunder. So therefore, old code will continue to have force. 2. Any penalty or imprisonment incurred in respect of any offence committed against the code so repealed. Therefore, any punishment given already under the IPC will hold good, and that punishment will not be in any manner affected because the act is repealed. Third one, next one is any investigation or remedy in respect of any such penalty or punishment. So therefore, if there is a right of appeal in respect of the punishment given under the old code, that the right will continue. You can do it under the new BNSS, not under the old code. This we have already dealt with. Suppose there is a prosecution for murder already, that was going on. Now after coming into force of this act, that trial will be continued and there will be punishment under the IPC. But so far as the remedy of appeal is concerned, it is to be done only under BNSS, that is a new act. That also we have already covered. Then next one is any proceeding, investigation or remedy in respect of any such penalty or punishment as aforesaid, and any such proceeding or remedy may be instituted, continued or enforced, and any such penalty may be imposed as if that code had not been repealed. These are all very easily understandable. Subsection 3 of section 358 says, notwithstanding such repeal, anything done or any action taken under the said code shall be deemed to have been done or taken under the corresponding provisions of this Sanhita. Here we should have a deep reading of this subsection. Notwithstanding such a repeal, that is, notwithstanding the repeal of IPC, anything done or any action taken under the said code shall be deemed to have been done or taken under the corresponding provisions of this Sanhita. Suppose a person is prosecuted under the IPC, he is convicted under section 302 IPC. Now what this particular provision conveys is that conviction is deemed to have been given under the corresponding new provision. I don't think that this will be correct, because it gives an initial impression like that. But if once there is a conviction under the IPC, it should be treated as a conviction only under the IPC, and it can never be deemed to have been convicted or imposed under the new code. So this provision is also slightly disturbing. This needs to be interpreted by the Honorable Supreme Court. A time will come, then we will have occasion to argue this also. Then subsection 4, the mention of particular matters in subsection 2 shall not be held to prejudice or affect the general application of section 6 of the General Class Act. So I do not want to go into section 6, what is the effect of repealing and saving classes, etc. I do not want to go into. So please have an overall or understanding of this provision only by keeping in mind two things. One, if there is already a prosecution, if there was an offence committed as defined in the IPC prior to 1/7/2024, the prosecution shall continue only under the IPC, number one. Number two, conviction shall be recorded only under the old code. Number three, the remedy of appeal is available for you, which you have to do it under the new BNSS, and this provision which says that if a conviction is recorded under the old code, which is deemed to have been imposed or recorded under the new code, is really a disturbing provision which needs to be dealt with by the Honorable Supreme Court. Time will come for that. So with this, let us see as to what are the major changes made in this IPC. I don't find any such major change except making some alterations in the matter of quantum of punishment. There is no much of change. Though it is said that IPC is a time-tested one, but still it is colonial. Therefore, a new penal code is introduced. But I don't think that anything done to completely repeal the IPC so as to nullify everything or to make new laws in the place of IPC. We will see as to what are the changes. First thing is in the definition class, gender. We know that there are only two genders as defined in the IPC, one is male, the other one is female. Now here, gender, the pronoun he and its derivatives are used of any person, whether male, female or transgender. So any person includes a male, female or transgender. Now transgender is also defined as a person. Under the old code, it doesn't mean that transgender is not a person and therefore a transgender cannot be convicted for any offence. Under the old code, if a person was born as a male, he was treated as he. So therefore he would be dealt with accordingly. If a person by birth was a female, irrespective of the fact that subsequently she had changed her sex, still she would be deemed only as a female because by birth she was a female. That is why by this classification, broader, only two categories, male and female, we were able to administer the Indian Penal Code for more than 150, 160 years. Now they are introducing, it is only clarificatory. We don't find anything new in it, but anyhow, to remove some doubt, they say that transgender is also a person. This is a change made in the IPC. This you will find in section 2, subsection 10 of the IPC. Now, having done this, now correspondingly, in the other provisions that follow section 2, whether anything is said about these transgender specially. Suppose a murder takes place, the definition clause says whoever or he, which includes a transgender also. A transgender can be therefore punished for any offence against the human body, like a male or female. But whether a transgender can be prosecuted for rape. Rape can be committed by a male. Now by this classification, you are trying to say that a transgender is not a male. A female cannot rape another female. A woman cannot rape another woman. There is no such provision. Similarly, my question is, having classified a third gender as a transgender, suppose that transgender commits any sexual offence, can you prosecute that person for rape or for molesting the woman? So this correspondingly, they have not made any special provision in respect of transgenders. You see the reverse. A male by birth undergoes surgery and now she is a transgender. Though he or she claims to be a female, as per law, he is not a woman or she is not a woman. He or she. He is neither he or she. She is a transgender now. Now question is, suppose that third gender, that is transgender, is subjected to sexual exploitation by a man, by a male, can he be prosecuted for rape? The definition of rape says that rape can be committed only on a female. Now, to my knowledge, let us see the corresponding provision to section 376. Corresponding. For a moment. See, rape. Now section 63. A man is said to commit rape. Can a transgender commit a rape under this act? Though a transgender by birth was a man. Now you say that he is not a man, he is only a transgender. Having created a third gender in the definition class, having excluded this third gender either from the definition of male or female or man or woman, have you made a special provision for them? It is not done. So please look at section 63 which is corresponding to section 375. A man is said to commit rape if he penetrates his penis to any extent into the vagina, mouth, urethra of a woman. So rape can be committed only on a woman. By whom? By a man. So transgender cannot be raped therefore. Transgender cannot commit rape also. Right? Now, let us go to the other provisions of the B. Inserts to any extent any object or a part of the body not being the penis into the vagina, the urethra or anus of a woman. Here also transgender is not there. Suppose there is penetration into the anus of a transgender. It's not rape. If the victim happens to be a woman alone, even inserting the penis into the anus is rape. Then manipulates any part of the body of a woman so as to cause penetration into the vagina, urethra, anus or any part of the body of such a woman. Therefore, quickly when I rush through these provisions, I do not find anything in respect of transgenders. Therefore, what as these provisions now stand, a transgender being, neither he or she, cannot be prosecuted for murder, cannot be a victim of murder also. This I would suggest to the government to think of amending this provision appropriately so that whenever and wherever a transgender is exploited sexually, there has to be a provision to punish the person concerned, be that a male or female. There has to be punishment for that. Now, having classified them as third gender, you are leaving them in lurch. You may recall that in one of my lectures in this Friday group organized by Seshu sir, we dealt with the property rights of transgenders. You remember that? See, suppose a Hindu male dies, the properties will be shared by the wife, daughters and sons. They are the legal heirs of the male who dies, a Hindu. Suppose a transgender dies. Transgender is neither a male nor a female. Who will take the property? Similarly, suppose a male dies, a Hindu, leaving a daughter and a son. Now son has become a transgender. When the father dies, the person who was born as a son, now a transgender, won't get any property because you say that he is not a man now. So this has not been clarified, that's what I say. So Hindu law should have been appropriately amended to give property rights to these transgenders as well. Similarly, in this IPC also, I find that though they have created a third gender, namely transgender, appropriately the other substantive provisions have not been amended, either to give any right to these transgenders to defend their body or and their property, and also to punish them for anything that they do against a female, that is woman or a man. So this requires some kind of change. Now, one more major change that they have done is by way of section 4 of this BNS, the old provision 53 dealing with punishment. What are the kinds of punishments? As per the old code, death is a punishment. Section 53. Imprisonment for life is a punishment. Imprisonment which is of two descriptions, namely rigorous or simple. They are punishments. Lastly, then next one is forfeiture of property. Last one is fine. These are all the punishments prescribed under the Indian Penal Code. Now, they have retained all these things. Apart from that, they have added one more thing, that is community service. Let me read section 4. The punishments to which offenders are liable under the provision of this Sanhita are death, as usual, imprisonment for life, imprisonment which is of two descriptions, namely rigorous, that is with hard labor, simple, forfeiture of property, fine or community service. Community service is a kind of punishment. In the penal provisions, they say in certain offences, the court is empowered to give this community punishment of community service. Having said this, they have not stated as to what are the services which are community services. They have not said. Community service, whether going to a temple every day and praying to God Almighty is a community service, or going to a school and to teach the students is a community service. What is that? It has been completely left to the discretion of the judges. They can say that they can direct him to do anything which, according to the learned judge, is a community service. Correct? He can ask, he can direct him to go and clean the school premises every day for 30 days. That is a community service. So what exactly is a community service which can be imposed by the court is completely and absolutely left to the discretion of the honorable judges. So this is the major change made. Then one more change is section 48 of the new code. Corresponding provision in the old code is not found. What is this is? This is really a welcome provision. Suppose an abetment to commit an offence take place. For example, a conspiracy which amounts to abetment take place not in Indian soil but in a foreign soil. For example, two Indians, they conspire there in a foreign soil to commit murder in India. Under the old code, because these two are Indians, though they commit the offence in a foreign soil, they can be prosecuted here in India for that offence after getting sanction from the central government under section 188 of the old code. No difficulty in that. Please keep in mind that two Indians commit offence of abetment on a foreign soil to commit their crime here, murder here. So this was covered under the old act. Now, a foreigner, a non-citizen of India, two people with another foreigner commit an offence of abatement there in a foreign soil to commit murder in India. under the old code, it was very difficult to bring those people to India to prosecute. Now they have introduced section 48, which says that a person, he need not be an Indian, any person, a foreigner, abates an offence within the meaning of this Sanhita, who, without and beyond India, abates the commission of any act in India which would constitute an offence if committed in India. So therefore, the foreigners, the terrorists sitting in other countries, they conspire there, they cause abatement to commit a crime in India, like Bombay blast, etc. They can also be prosecuted here in India as per section 48. Then under the old code, really in practice, the authorities were struggling to bring those foreigners here to prosecute. Now it has been rectified by this provision. Then the other one is regarding marital rape. This is a very debatable issue which has been going on in this country for quite some time. Whether a man can commit a rape on his legally wedded wife. When sexual or physical relationship is established against her consent, whether the wife needs to give consent for physical relationship, sexual relationship. This debate has not ended. In the old code, IPC, what was said was that sexual intercourse or sexual acts by a man with his wife, the wife not being under 15 years of age, is not rape. This is the explanation 2 added to section 375 definition. Now therefore what it conveys, if there is a legally wedded, if there is a legally performed marriage, the girl is more than 15 years of age, more than 15 years of age. With that girl, if the husband, without her consent, establishes sexual intercourse, then it is not a case of rape at all. The benchmark is 15 years. Though in law, on the civil side, the marriageable age is 18 years. Under the Hindu law, section 5 says that the girl should have completed 18 years of age. But here is a girl who is married at the age of 15 or at the age of 16. The husband, as usual, without knowing the effects of law, has sexual intercourse with her. Now, it is no offence as per the old code. Now what they say, they have increased the age from 15 to 18. This is in tune with the POCSO Act. Under the POCSO Act also, though there was a marriage between a man and a girl who is less than 18 years, it is an offence under the POCSO Act. In tune with that, now they have amended this explanation 2 to section 375, which says sexual intercourse or sexual acts by a man with his own wife, the wife not being under 18 years of age, is not rape. So therefore, there is no marital rape if the girl is more than 18 years of age. Though there was a marriage for a girl who is less than 18 years of age, though the husband may be under the impression that because he is married, he has got every right to have sexual intercourse with the girl who is less than 18 years, law now declares that it is, though there was marriage, it is a rape as per section 375 explanation 2. So this is a major change made in this. Now one more provision is section 69, which has also been introduced for the first time. There was no equivalent provision. But still we were able to manage with the existing provisions, and now they have made a special provision. which is sexual intercourse by employing deceitful means, etc. This is whoever by deceitful means or by making promise to marry a woman without any intention of fulfilling the same has sexual intercourse with her, such sexual intercourse not amounting to the offence of rape shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. This is here, some concession has been now shown. Deceitful means, whoever by deceitful means, suppose a man gives some kind of false promise, he deceives a woman, gets consent. Out of that consent, she allows him to have sexual intercourse with her. It is certainly rape as interpreted by this Supreme Court. Consent should be a free consent. If consent is obtained by deceitful means, it is no consent in the eye of law, and therefore he is liable to be punished for rape. It is already there. Now they say they have reduced the punishment. Punishment is only 10 years now. Earlier it was life. So there is a conflict. That original provision is also still there, which prescribes the punishment of life. Suppose the consent is not a free consent, it is a clear case of rape. If it is a rape, sentence can be up to life. Now they say, no, sentence is only 10 years. So this is in contradiction to the earlier provision and the corresponding the new provision also. This also requires relook by the government. Then one more thing is marital, that is by making promise to marry. By making promise to marry, if a woman's consent is obtained and the man has established sexual intercourse with her, under the old code it was a rape. Here they have made a special provision. Here also they say that it is not rape. It is that they exclude this. It is not rape, it is no more rape. What they say, whoever by making promise to marry a woman without any intention or fulfilling the same has sexual intercourse with her, such sexual intercourse amounting to the offence of rape, not amounting to offence of rape. So as per this provision, it is no more a rape. It is no more rape. So giving false promise to marry without any intention to marry at all and getting consent from her was originally under the old code a clear case of rape. Now they say it is not rape, not amounting to rape. Then what is it? Here sexual intercourse done after getting consent by false promise to marry, which is punishable only up to 10 years. See, in the explanation, what is deceitful means is also explained. Deceitful means shall include inducement for or false promise of employment or promotion or marrying by suppressing identity. These are all the case of getting consent which is not a free consent. Therefore it must be rape. But they have now said that it does not amount to rape. This is another provision made. Then one important provision is this is section identity of the rape victim should not be disclosed, and if it is disclosed, offense, it is an offence punishable up to 2 years. So that also the press people and others and the people who are reporting the cases must be very cautious, and nothing could be published indicating the identity of the victims. of rape. Then coming to murder, so earlier provision is 302, now it is 103. Now they have added only one thing, that is subsection 2 of section 103. This, in my view, is an unnecessary provision. I will read it, you will understand as to why it is unnecessary. When a group of 5 or more persons acting in concert commits murder on the ground of race, caste or community, sex, place of birth, language, personal belief or any other similar ground, each member of such group shall be punished with the death or imprisonment for life and shall also be liable to fine. Why this provision? Already we have got 149. Under the World Code there is a corresponding provision. When a group of 5 or more persons acting in concert, that is, there is common object, they commit some offence for some reason or the other, like sex, place of birth, etc. Common object is there, they can be punished by invoking the old provision 149, the corresponding new provision. But they have made this provision also, which in my view is unnecessary. The original provision itself will take care of. So this is section 103, subsection 2. Otherwise, in respect of the definition of culpable homicide, in respect of the definition of murder, in respect of the exceptions to section 300, and in respect of the quantum of punishment under 302 and 304, there is no change at all made. So all those judgments which we have been all along following for more than 150 years will hold good, and so far as, see, murder is a very serious offence in the Act. So there is no change made except this very small change. It is almost like clarificatory. And other things, you know that hit and run cases, instead of 304A, now they have made, this is section 106. Now earlier, under 304A, whoever causes the death by doing any act, rash or negligent act. Now specifically they have brought into the scope of section 106 the medical negligence. So having said that it is medical negligence, what is the gravity of the negligence which is required of is not explained. I will read the provision. Whoever causes the death of any person by doing any rash or negligent act, not amounting to culpable homicide, shall be punishable with imprisonment of either description for a term which may extend to 5 years. Earlier, it was only 2 years, now it is 5 years. And shall also be liable to fine. And if such act is done by a registered medical practitioner, this is important. And if such act is done by a registered medical practitioner while performing medical procedure, he shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. So this is again nothing but in a way a clarificatory one. Earlier on the 304A itself we were prosecuting the doctors, we were also punishing. Now they have clarified that, saying that if it is a medical negligence, then the punishment will be 2 years. Here one more thing is either rashness or negligence. It is not rash and negligence as per the ME Act. Rash or negligent act. That also you have to consider. Then who is a registered medical practitioner? He is also explained. Then subsection 2, whoever causes death of any person by rash and negligent driving of vehicle not amounting to culpable homicide and escapes without reporting, that is hit and run case. The sentence is 10 years and shall also be liable to fine. So hit and run case, you would have seen in the newspaper that there was large scale objection to this. Therefore the government has not notified this particular provision, this has not come into force. Therefore for the present let us not worry about this provision. Then yet another major, before concluding because my time is up, major change made is in respect of organized crimes and terrorist acts. So these provisions, these offences were already dealt with under UAP Act, and like local acts like Maharashtra Organized Crimes Act, etc., etc. We have got experience with those acts. Now, in the like UAPA, the provision provisions of offences of organized crime, terrorist act have been made punishable under this act itself. Therefore, if there is a terrorist who indulges in terrorist activity, he can be prosecuted both under the special law as well as under this act. But punishment is to be imposed only under one act. This is another major change made. This is regarding terrorist act, petty organized crime, then organized crime, etc. These things you can understand. Then act endangering sovereignty, unity and integrity of the nation. The original section 124 is under challenge over the Honorable Supreme Court. It is pending. Therefore, they have made some change in that. They have made section 152. This will also be considered with the Honorable Supreme Court at the appropriate stage. So finally, instead of 511 sections under the old code, now they have reduced it to 358 sections. That's the only change. Otherwise, all these colonial provisions, so which according to them, the person who brought this, they say most of the provisions are colonial, therefore we want to change. So these are all the changes which I have brought to your notice. Where is the question of removing the colonial elements from the Indian Penal Code? So what I feel now at the end is that these three laws have been now brought into force. It is for the lawyers community to understand that and take it forward. And if really the intention of the government, as it is claimed, is to have speedy investigation, is to have speedy trial and see that the culprits are punished at the earliest, it is in the hands of the lawyers and the judiciary in particular to understand these three laws and to take it forward. And with this, I want to conclude. My time is over, and I thank all of you once again with folded hands for the wonderful cooperation and encouragement given to me for 5 days continuously to deal with many of the provisions. I feel guilty that I have not gone very deep into many of the provisions for paucity of time. And you are all great lawyers, seasoned lawyers. So I have only initiated some debate on various provisions. It is for you to continue with the debate and to see that the nation is benefited by proper interpretation of it. Thank you so much.
Thank you very much, sir. Valuable time and valuable 40 years experience, the way you made it. I am very grateful to you on behalf of Friday group members. Highly, extremely grateful, sir. The way you enlighten us. Akal mand ko ishara kafi hai. That part, I mean, Gitanjali is saying. Given a hint, that's more than enough. We will pick, sir. I mean, if there is anything, again, you are here, we will get. I request Anubha Dulia will give a vote of thanks. I mean, one second. She is going to give part 1, 2, 3, 4 today's also.
Sir, first of all, my namaskar to all and everybody sitting here. Sir, very warm and graceful evening since I am addressing you for the first time, sir. I am most privileged to stand here and propose my vote of thanks to none other than Justice Nagamuthu, Senior Advocate of the Supreme Court of India. I am doing this not alone, but on behalf of the entire Friday group, everybody who is sitting here, everybody who would be benefited by the lectures you have given for the 5 continuous days. Sir, you started the lecture by saying, sir, I'll take the seat. I'm so sorry because of the camera. So you started the lecture by saying that you never prepare for any of your lectures because 43 years stand behind you, and naturally that would not require. But sir gave dedicatedly 7 days for these 5 lectures, and I think many more hours while he was amongst us, giving these lectures, getting into the nuances of each and every law, that we have discussed here. Sir, it was not only reflected in what we heard. In fact, by the pin drop silence in all these 5 days, what I and everybody here have realized, we have gone back to the aisles of our college when we used to listen to our professors carefully. We have been hooked to each and every word, each and every line, sir, you have shared with us. Sir, you have not only shared the interpretation differences which was meticulously prepared by the team, I'm sure, but more than that, sir, you have given us the perspective to look into the provisions and the way perhaps the highest court of this country would interpret the provisions in future, which is very enlightening for all of us, sir. Sir, now I'll go into the details of what we have discussed. Sir, I might not be able to cover each and everything, but I'll try to just pick up few things that we have covered in our journey of 5 days. So we have covered 3 laws, which is Bharatiya, Nagarik, Suraksha, Sanhita, Bharatiya, Sakshya, Adhiniyam, and Bharatiya, Nyaya, Sanhita for 5 days, where for the first 3 days we have discussed the first law, which is the Criminal Procedure Code, the new Criminal Procedure Code. So we started with the repealing and saving section, the section which we have never studied in our classrooms. We are students who are born in 80s, so we never came across this section ever, and how at all it would be interpreted, if at all it would be. So this was something that was such a big addition, how we look into and how we interpret the repealing and saving section term. So we covered mostly, we started with how the applicability to the present pending applications and other proceedings would be. We went ahead to understand that what would be those applications which will become the integral part of the trial and would be governed by the old law. At what instance the new law would be, new code would be applicable so far as the procedural criminal procedure code is concerned. We also understood, sir, that how the new laws have been introduced in our BNSS, which is in way of preliminary inquiry, which is now statutorily introduced, but at the same time is very different from what it was in Lalita Kumari case. Sir, we were also enriched by a very new change which has never been done before, which is abolition of certain courts, which are primarily 2 courts, which is the Metropolitan Magistrate, and then there is the assistant session judges have been abolished. However, for all practical purposes, how the 2 designations will still be around for the pending cases till the last case is disposed is also what we have understood. So the courts will still remain with us for some years at least, until those cases are withdrawn. So we also dived deep into the changes which have been made in the investigation, starting from the registration of FIR, where we have seen that how a change, but significant change, has been made when the application is moved to the magistrate after, if at all, the superintendent of police fails to register. We have gone ahead to see how there is a new addition, which is in terms of information by electronic means, and how at the same time it might not be as effective as perhaps the intention of the legislation might be. It is for the reason how Sir very precisely told that in any case the person has to come and sign the information, and that is why it might also go into the confusion of what would be the first information and what would be the second information. We have gone ahead to understand even that how there are additional safeguards, that is on the second day of the lecture, there are additional safeguards which have been given to the public servant, Then we have gone into the details of the private complaint and the changes therein. We have also seen how there is a very significant addition in terms of forensic experts now, who are now mandated to go to the crime scene immediately after the receipt and registration of the information. Then there are minute changes so far as the recording of statement is concerned. Then we have also gone into, on the third day, on the period of remand, on custody, the right of bail, how it would be affected, questions that would, and this of course includes the questions which have also been forwarded to the larger bench. Then there is also, we also got to understand how police custody has to be asked, and one has to be present before the court along with the accused as well. On the third day, we have also covered the final report. We have covered private complaint where there has been a major changes. Then we have seen how the copies would also be supplied to the accused. The committal of case again was gone into detail. Sir, I might not have covered everything, but I have tried to touch upon the aspects that we have covered for BNSS. On the fourth day, sir, we went into the journey of the evidence law, and we have understood that more or less it remains the same. However, I think what affects all of us is when we put the affidavit of 65B we used to put, and I think on 2nd of July itself I had to put on under section 6063, and I have not understood in fact the nuance difference between the two, the digital records particularly, and we all were benefited by it. And I think nowadays we hardly file any petition without 65B or any replies. So today we have understood, on the last day we have also understood the penal court. We have gone through certain sections to understand that there are only minor changes, more of it clarificatory. However, I'll again connect the lectures to the very first day when you said the laws are nothing but they are wrapped in a new colorful bottle. And we have also seen, and the concern of the rules, the law being colonial has not been addressed. Again, on the very first day, we were told that the very two issues behind the criminal law, which are with respect to the miscarriage of justice and the speedy trial, all in all, we don't see that they have been primarily addressed here. And after understanding whatever we have gathered through these lectures and what we will experience now for years to come while we read, we understand, and we also think that more or less the very old cases are precedents are still to remain for years. We are still going to remain referring to those cases. So all in all, we are indebted to you, sir, for such a deep understanding of all the laws which we will be using throughout our practice, and we are thankful on behalf of the entire Friday group, all the audience. Thank you so much.
Thank you, Anubhav. So nice of you covered everything. Now we'll give a bouquet of flowers to sir on behalf of all of you. Sweets open, sir. Now sweets are available here. Kindly wait for. Open, sir. It's from Canada.
And it's good reading.
Sir, from myself, sir, please. Sir, you take it. Only after you. Take it, sir.
Please come one by one. Please come. Aye, please come. Plates I can Vinod.